This video will explain criminal investigation procedures in Japan. Japanese laws clearly define what kind of behavior is considered criminal and lay down the punishment for each type of crime. The laws also state the judicial procedures which must be followed in allotting punishment. Japanese court decisions are based on statements by defendants, eyewitnesses, and other witnesses, and on physical evidence. In other words, all criminal proceedings are based on the law, and punishment is only imposed after a judgment based on the law and the evidence presented. When a crime is discovered, the investigating authority will gather evidence to show who committed the crime and may arrest the person responsible. In addition to police investigations, certain types of crimes are investigated by other authorities, such as maritime safety officials or officers of the Narcotics Bureau. The public prosecutor directs investigations conducted by other authorities, and in certain cases makes its own independent investigations. Suspects may be arrested and detained in custody, and the conditions under which this is permitted are clearly stipulated by law. There are three categories of arrest. In an ordinary arrest, a judge first issues an arrest warrant for the investigating authority to arrest the suspect. An emergency arrest is permitted for certain types of serious crimes. If there are sufficient grounds for believing that a suspect has committed the crime and swift action is necessary, the investigating authority may arrest the suspect first and procure a warrant from a judge as soon as possible afterwards. In the case of an ordinary arrest or an emergency arrest, the judge will issue a warrant only after examining the evidence and deciding that there is reasonable cause and necessity to detain the suspect. The third type of arrest is an arrest of a flagrant offender. The police or any member of the public may arrest without a warrant a suspect who is committing a crime or who has just committed a crime. In short, Japanese law only permits the arrest of a suspect when there is reasonable evidence implicating him or her in a crime. Immediately after a suspect is arrested, the investigating authority must inform the suspect of the crime with which he or she is accused, and that he or she has the right to retain a lawyer. The suspect must then be given an opportunity for any explanation he or she may wish to offer. If a suspect has been arrested by an authority other than a public prosecutor or a public prosecutor's assistant officer, or by a member of the public, and if detention is required, the suspect, together with all relevant documentation and evidence, must be transferred to a public prosecutor within 48 hours from the time of the arrest. After the suspect is handed over to the public prosecutor must provide the suspect with an opportunity for explanation. The public prosecutor will then decide whether or not continued detention is necessary. If the public prosecutor decides that custody is not necessary, the suspect will be released immediately. However, if the public prosecutor decides that custody is necessary, then the public prosecutor must formally request a 10-day detention order from a judge within 24 hours of receiving the suspect. The public prosecutor may also formally institute a criminal action against the suspect within this 24-hour period.